Hello friends and welcome to Gradeup. Hello everyone and welcome to Gradeup. So today we start with a very special series where we discuss some very important judgments that has been rendered by the Honorable Supreme Court. So as you know that the Supreme Court is the apex court of the land. Whatever it decides becomes the law of the land. Today we aim to discuss some very important judgments that have changed the polity of our social living. Today being the first class, we ask ourselves one very important question, which a lot of students have asked me, is whether the preamble of the Constitution, whether the preamble to the Constitution of India is a part of the Indian Constitution or not. So we ask ourselves whether the people who framed the Indian Constitution felt for a need that the preamble should be a part of the Constitution or should not be a part of the Constitution. This is the precise question that we are going to answer. The preamble and the Constitution. Whether the preamble is a part of the Constitution, number one. And secondly, we are going to also ask ourselves whether the preamble can be amended by the Parliament. Am I clear? So today we are going to ask ourselves two important questions. Whether the preamble is a part of the Constitution, number one, and number two, whether the preamble can be amended or not. Okay? So we start. Today we are looking at three very important judgments. Three very important judgments that has been rendered by the Supreme Court. Number one, we look at in re Burberry Union's case that was decided by the Supreme Court in the year 1960. Then we also are going to discuss the landmark judgment of the Supreme Court in IC Golic Not versus State of Punjab. And finally, we are also going to discuss and understand for ourselves what the Supreme Court held in Keshwananda Bharati versus State of Kerala, which the Supreme Court decided in 1973. These are the three landmark judgments that we are going to discuss today. Okay, welcome all of you from Gradeup. So today we are going to understand three important landmark judgments. What was held by the Supreme Court in these three landmark judgments, and finally conclude for ourselves whether the preamble forms a part of the Constitution or not. And secondly, whether the preamble of the Constitution can be amended or not. Am I clear? So we start with the preamble itself. The preamble to the Constitution of India, as you know, is a one-page document. The preamble to the Constitution of India is just a one-pager document which states, and I quote, and it's up there in the slide, "We the people of India," that means the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens, number one, justice, whether it is social, economic, or political. Number two, liberty of thought, expression, belief, faith, and worship. Number three, equality of status and opportunity. and to promote among them fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So this is what the preamble of the Constitution says. The preamble of the Constitution very categorically states that the people of India, that it was not a constitution that was forced upon the people of India by the British Raj. It was we have given ourselves this solemn constitution which provides sovereignty. Number one, very, very important. Socialist, secular, and democratic republic to ourselves. These are the couple of words that are enshrined under the preamble. Now, the question that we have raised today in this session is whether this preamble is a part of the Constitution, because Constitution of India starts from Article 1 onwards, and the preamble is just a prefix to the Constitution alone. So the question right now is whether this preamble that you see on your screen forms a part of the Constitution or whether it does not form a part of the Constitution. Am I clear, friends? So this is what we are going to look at today. Am I clear? Okay. So first and foremost, okay. Yeah. So let's start with the first important judgment that was rendered in the year 1960. And it was a reference case, a reference of the Burberry Union. Okay. Now, there were a lot of princely states. Okay. Now, after the partition of India, between India and Pakistan, there were certain lands that had to be divided between India and Pakistan. So some land was divided in the state of West Bengal between India and Pakistan in the district of Jalpaiguri. So there is a place called Jalpaiguri in West Bengal. Some of its land went to what we today call Bangladesh, that was earlier known as Pakistan, right? So some of the land went to Pakistan and some of the land was given to India. Now the question came. Now there was a lot of questions. You don't need to go into those important questions, whatever it is. Now the question was, there was also an issue before the Supreme Court whether the preamble is a part of the Constitution. Am I clear? Whether the preamble is a part of the Constitution. Now, the Burberry Union, which had a part of land in what we call as Jalpaiguri district of West Bengal. Okay. Now, this land stood divided between India and Pakistan. Now, the question before the Supreme Court was whether the preamble is a part of the Constitution. The Supreme Court said, and I quote, "There is no doubt that the declaration made by the people of India," that means the declaration made by the people of India means the preamble. The declaration that is made by the people of India in exercise of their sovereign will in their preamble, because they enforce their sovereign will in the preamble to the Constitution, and it said is a key to open the minds of the makers. So preamble is a key to open the minds of the makers of the Constitution, which may show the general purpose for which they made the provisions of the Constitution. But nevertheless, please come over here, but nevertheless, the preamble is not a part of the Constitution. Please keep this in your mind. So in Burberry's case, the Supreme Court held that the preamble is not a part of the Constitution. Am I clear, friends? So In Burberry's case, the Supreme Court, while deciding this case by a bench strength of 7 judges, keep this in your mind, this was not a 2-judge bench or a 3-judge bench judgment. There was 7 judges sitting together and they decided this case. And they held in the year 1960 that the preamble is a declaration made by the people of India. And that is the reason why the Constitution starts from Article 1 onwards. Am I clear? So the Constitution itself starts from Article 1 onwards. Am I clear? And it finally held that the preamble is not a part of the Constitution. Furthermore, the Supreme Court held. What did it held? Look over here and understand. At the highest, at max, it may help, it may perhaps be arguable. It can be argued that if the terms used in any of the articles in the Constitution, that is which starts from Article 1 onwards, are ambiguous or are capable of having 2 meanings, then preamble can be used as a source of interpretation. Am I clear? Very, very important. What the Supreme Court held in Burberry's case is that they held that the preamble is not a part of the Constitution. But it at max they can hold that in case there are certain articles where there is ambiguity, where there is a possibility of having 2 meanings. Now, to interpret those articles, the assistance of the preamble can be taken. Am I clear, friends? So, in Burberry's case, the Supreme Court held that the preamble is not a part of the Constitution. Now, let's come to the next important case. The next important case is IC Golic Not, a very, very important case of the land. A judgment, a case that was decided by 11 judges. Keep this in your mind. A strength of 11 judges sat. Okay. Now, what were the issues involved? The issue was whether the preamble is a part of the Constitution, number one. And number 2, there was another issue. Can the preamble limit the power of the Parliament insofar as amendment of the Constitution is concerned under Article 368? Now, first let me tell you what is 368. Article 368 of the Constitution of India empowers the Parliament to amend the Constitution. Am I clear? So, there is a provision called Article 368 of the Constitution of India which empowers the Parliament to amend the Constitution. Now, the question before the Supreme Court was whether the preamble is a part of the Constitution, number 1, and number 2, whether the preamble can limit the power of the Parliament to amend the Constitution. Now, what did the Supreme Court do? The Supreme Court heavily relied on the judgment of Burberry's case. The Supreme Court relied upon it. It depended on the earlier case that I decided and that I spoke about right now. Okay. Now, the Supreme Court held that we are of the opinion, okay, we are of the opinion that the preamble cannot prohibit or control in any way or impose any prohibition, okay, prohibition or limitations to the power to amend the Constitution of India. That means the Supreme Court held that the preamble cannot impose any prohibition or limitation on the power of the Parliament to amend the preamble. Am I clear? Okay. Am I clear? Yeah. So this is a judgment that is rendered by 11 judges, friends. Okay, this is a judgment that was decided by 11 judges. Okay, yeah, there is a difference between 3 judge, 5 judge, 9 judge. Okay, now a 5 judge bench can definitely overrule a judgment that is rendered by a 3 judge bench. A 9 judge bench can overrule a judgment that is rendered by a 5 judge bench, or a 3 judge bench, or a 7 judge bench. So I'll just tell you this. Suppose there is a 3 judge bench, okay, which says preamble is a part of the constitution. A 5 judge bench can say preamble is not a part of the constitution. Am I clear, friends? But a 7 judge bench can definitely say preamble is a part of the constitution. Am I clear, friends? Did you understand what I'm saying? So the higher the strength of the judgment, a lower a judgment that is rendered by a court of lesser bench strength can be overruled by a larger bench strength. Am I clear, friend? Okay, so the Supreme Court in Golic Not versus State of Punjab in the year 1960, relying on Burberry's case, held that preamble cannot prohibit or bring about a limitation insofar as the power of the parliament is concerned, insofar as amendment to the constitution is concerned. Am I clear, friends? Okay. Okay. Any doubt? Okay. Further, the Supreme Court said, although the parliament has the power to amend the constitution. Now, very, very important, please. The Supreme Court held that although the parliament has the power to amend the constitution, but there has to be some implied restriction. Very, very important. Now, this part of the judgment gave birth later on in Keshwananda Bharati's case to the concept of basic structure. Am I clear, friends? Now, please try to understand. The Supreme Court said that yes, preamble cannot impose any limitation insofar as the power of the parliament is concerned qua amendment to the constitution. Am I clear? Further, the Supreme Court said that although they agreed that the parliament has the power to amend the constitution, they also felt that these powers are subjected to some restriction or some limitation. Am I clear, friends? Am I clear? Furthermore, so what does IC Golic Not in a nutshell say? It says that although the parliament has the power to amend the constitution, there are some implied restrictions. That means parliament cannot amend something that is basic. Am I clear? Am I clear? So in IC Golic Not, the Supreme Court held that the preamble is not a part of the constitution. Am I clear? Am I clear, friends? So in IC Golic Not, the Supreme Court held that the preamble is not a part of the constitution, as was held by Burberry's case. But the Supreme Court said that since there is a restriction insofar as amending the fundamental rights is concerned, since there is a particular provision of the constitution which prohibits the parliament from amending the fundamental rights is concerned, the Supreme Court came to a conclusion that the parliament cannot amend the fundamental rights. Very, very important. Am I clear? Very, very important. It said very categorically that the parliament cannot amend the fundamental rights. Am I clear? Am I clear, friends? So this is what was held in IC Golic Not. So first in the case of Burberry, the Supreme Court held that the preamble is not a part of the Constitution. In Golic Not also, in IC Golic Not also, the Supreme Court held that the preamble is not a part of the Constitution. Am I clear? Then comes the most important judgment of the Supreme Court. This is a judgment called Keshwananda Bharati versus State of Kerala. A bench of 13 judges, decided this case in the year 1973. A bench of 13 judges decided this case in the year 1973. Now, what were the issues involved? There were a number of issues involved. Now, in this class, we are concentrating whether the preamble is a part of the Constitution or not. Am I clear? So, we have to answer at the end of the class whether the preamble forms a part of the Constitution, whether the preamble is not a part of the Constitution. Am I clear? So this is the limited question we are asking ourselves. So let's see what was held in Keshwananda Bharati's case. The issue was whether the preamble is a part of the Constitution, and secondly, can the preamble limit the power of the Parliament qua amendment to the Constitution is concerned? Same questions were raised. Along with these, there were a lot of other questions. Today we are restricting in this class these questions which are related to the preamble. Am I clear? In some other class, we will discuss amendment in details. Okay. Now, what did the Supreme Court held? Supreme Court held by a 13-judge bench, very, very important, that preamble is a part of the Constitution and can be amended by the Parliament because the Parliament has the power to do so under Article 368. Am I clear? Am I clear? Now, what do you mean by amendment? Amendment means any addition, any omission, any substitution. Okay, so any addition, any omission, or any substitution to an existing provision is called an amendment. Am I clear, friends? This is called an amendment. Am I clear? So in Keshwananda Bharati's case, the Supreme Court held that the preamble is a part of the Constitution, and the Parliament, because it is vested with the power of amending the Constitution under Article 368, can also amend the preamble. Am I clear, friends? Okay. The power to amend the Constitution provided under Article 368 of the Constitution is not unlimited, but there are some implied restriction. Now, what is this implied restriction? The Supreme Court said that, look, I can understand that the Constitution of India provides the legislature, that is the Parliament, to amend the Constitution, but this power of amendment is not unlimited. There are certain implied restriction. There are certain restriction. Now, let's understand what are these restrictions. Now, this statement of the Supreme Court, please come over here. This statement of the Supreme Court which says that there are certain implied restriction on the Parliament insofar as the amendment to the Constitution is concerned, gave rise to the concept of basic structure. Please try to understand this. Okay. This concept, this implied restriction, please, this word called implied restriction gave birth gave birth to the concept of basic structure. The Supreme Court held that the doctrine had come up with a doctrine of basic structure. Now let's see, what is this doctrine of basic structure or a doctrine of limitation? Okay, now what do we mean by basic structure? The Supreme Court said that, look, Parliament, I understand that the Parliament has the power to amend the Constitution, but can it amend the Constitution in such a way that the basic pillars on which the Constitution rests is destroyed? Now, for example, I'll just give you an example. Now, what is the basic structure? Now, when we were taught basic structure back in law school, we were given a fantastic example. And the example goes like this. Suppose you have a house. Okay, you are building a house. Now, in a house, you have doors, you have windows, you have mirrors, right? You also have those pillars on which the house rests. Am I clear? Suppose for example, I am to build a house. Now, I have to build a pillar over here, a pillar over here, a pillar over here, and another pillar over here. Okay, this is attached to here, this is attached to here, this is attached to here, and all. Am I clear? So, am I clear? This is the basic structure on which the house rests. Now, inside the house, you can have doors, windows, you can have basin, you can have washroom, you can mend everything. Now, the doctrine of basic structure is very close to a house. The Supreme Court said that if tomorrow your door is getting old, is getting destroyed, you can change the door, you can change the window, you can change the glass mirrors, but you cannot change this basic structure. Now, if you break these basic pillars on which a house rests, will the house survive? No. Similarly, there are certain basic pillars on which the Constitution survives. Am I clear, friends? There are certain basic pillars on which the Constitution survives. Now, if the Parliament tomorrow breaks those basic structure, basic pillars of the Constitution, will the Constitution survive? The answer is no. Am I clear, friends? Did you understand what I'm trying to say? So the doctrine of basic structure simply says that the Parliament has the right, has the prerogative to amend the Constitution, including the preamble. But while doing so, it cannot interfere with the basic structure or the basic tenets of the Constitution. For example, can the Parliament tomorrow change India from democracy to a dictatorship? The answer is no. Am I clear? Am I clear, friends? Can the Parliament tomorrow change India from a secular country to a Hindu country? The answer is no, because secularism, democracy are basic features of the Indian Constitution, which even the Parliament cannot change. Am I clear, friends? Did you understand? Okay, Parliament has the right, has a prerogative, has the power to amend the Constitution. But the power to amend the Constitution is not unlimited. There are certain limitations. There are certain limitations on the power to amend the Constitution. Am I clear? So finally, a 13-judge bench in Keshwananda Bharati Finally, a 13-judge bench in Keshwananda Bharati held that the preamble is a part of the constitution. Am I clear, friends? Did you understand? So, in re Burberry, the Supreme Court said preamble is not a part of the constitution. In IC Golic Not, the Supreme Court said that relying on in re Burberry, the Supreme Court said that the preamble is not a part of the constitution. But in Keshwananda Bharati's case, a 13-judge bench of the Supreme Court decided that the preamble is a part of the constitution, and the power of the parliament to amend our constitution is subjected to certain limitations. Am I clear? So now let's understand what are the basic features of the constitution or the basic structure. What are those basic structure of the Indian constitution? Examples are free and fair election. Now, can tomorrow the parliament say that India from tomorrow will be a monarchy like UK? No, India cannot say that. Am I clear? The parliament cannot change the Indian constitution that from tomorrow India will be a dictatorship or a monarchy. Am I clear? Secondly, supremacy of the constitution. The Supreme Court said that the parliament cannot tomorrow change the constitution in such a way that the supremacy of the constitution is taken away. Now, what does it mean? It simply means that all laws, now understand this, that the Constitution of India is the mother of all laws. Is the mother of all laws. All laws gets their power from the Constitution of India. So, supremacy of the Constitution forms a basic feature or a basic structure of the Constitution of India. The other important basic structures are independent judiciary, that the legislature or the executive cannot interfere with the courts. Now, we had seen how legislature or the executive interferes with the judiciary. Now, the basic structure doctrine states that independence of the judiciary should be insulated from the legislature, the power of the legislature, as well as from the executive. That is called independence of the judiciary. The other important basic features of the Indian Constitution is called secularism. The state should not distinguish a person on the basis of his religion. Hindus, Muslims, Jains, Sikhs, Christians, they are all equal in the eyes of the state. Now, for example, what is secularism? If a Hindu commits a murder and a Muslim commits a murder, is the punishment the same? Yes, that is called secularism. Suppose a Hindu wants to stand for an election. A Muslim can also stand for an election, a Jain can also stand up for an election, as well as a Christian can also stand for an election. That is called secularism. That means there should not be any distinguishing factor insofar as a person's faith or religion is concerned. Am I clear? Am I clear? Okay. Furthermore, the Supreme Court said that separation of power. The legislature acts in its own way, the executive acts in its own sphere, and the judiciary acts in its own sphere. The legislatures, what is the power of the legislature? What does the legislature do? It legislates. Power to make law. What does the executive do? It implements the law. And what is the role of the judiciary? It interprets the law. Am I clear? So the there is a complete separation of power that we see in the Supreme Court or in the Constitution, that the power of the courts is to interpret the law, is to resolve dispute. Am I clear? Am I clear, friends? Legislature's power is to make law. They make laws inside the parliament. The executive's power is to implement the laws that are made by the legislature. Am I clear, friends? Am I clear? Now, the question is, since we have arrived to a conclusion that the preamble is a part of the Indian Constitution. Now, can the preamble be amended? Yes, it can be amended. Am I clear? So the preamble to the Constitution of India can be amended. Am I clear, friends? It's a very, very important thing for all of you, especially for those of you who are sitting for AILET, MHA, CET, symbiosis and other law entrance examination. Even for your Clat, they can give you a passage, a big passage from Keshavananda Bharati's case and ask you a couple of questions. From IC Golic Not case, they can just pull a passage from IC Golic Not's judgment and then give it to you and ask a couple of questions. So in such a way, these classes are important for people who are sitting for Clat as well as other law entrance examination. Am I clear, friends? Okay. So let's understand whether the preamble can be amended. Yes, it can be amended, and it has been amended. It has been amended once by virtue of the 42nd constitutional amendment that took place in the year 1976 during the emergency of India, which we call as the internal emergency or Indira Gandhi's emergency. So during Indira Gandhi's emergency, this preamble was amended. Am I clear? Am I clear, friends? So the 42nd amendment of the Constitution of India amended the preamble. And what was the resultant? The word socialist, the word secular was added. The word unity of nations was changed into unity and integrity of the nation. Very important. So first and foremost, the word socialist and secular was added. Am I clear? Very, very important. The word socialist and secular was added. And secondly, the word unity and integrity of the nation was changed from just unity of the nation. Earlier it was just unity of the nation. It was changed into unity and integrity of the nation. Am I clear, friends? Okay. Am I clear, friends? Okay. So the preamble forms. So finally we have arrived to the conclusion today. Initially in the class, we did ask ourselves a question that whether the preamble is a part of the Constitution. And the answer is before you. The preamble is a part of the Constitution. The second question that we had asked ourselves initially in the class was whether the preamble can be amended. The answer to this question, yes, it can be amended. Am I clear, friends? So the preamble forms a part of the Constitution and it can be amended. It was amended in the year 1976 by virtue of the 42nd constitutional amendment, by virtue of which the word socialist, secular was added and the word unity of the nation was replaced by unity and integrity of the nation. Am I clear? So with this, we come to the end of today's class. With this, we come to the end of today's class. Today, we are launching today we are launching our crash course for Clat, AILET, MHCET and other law entrance examination. So today we are launching, today is the 2nd of April. Today we are coming out with a crash course on Clat and other law entrance examination. Am I clear, friends? So I would request all of you, stay home and keep yourself in a healthy position so that you can prepare. You don't need to come out of your home, and that is the precise reason why Gradeup is providing you with such video classes, by virtue of which you don't have to step out of your home during the current lockdown, but you can prepare well for your Clat and other law entrance examination. Am I clear, friends? Yeah. Someone has, sir, can you explain in Hindi too? It would be more productive. Funland has asked me this question. Okay, friend, I don't mind speaking in Hindi, but the fact is this. The question, this exam is the mode of this exam is English only. So you have to be a little good with your English, so that the exam is asked in English. You have to understand the English. It is not held in Hindi, friends. Am I clear? Yeah. So we will definitely let you know at 8 o'clock today. We are launching at 8 o'clock today. We are launching the crash course in YouTube. We will let you know the fees, the course fee for the upcoming crash course that we are going to launch today. Am I clear, friends? So today we are going to launch a crash course. Everything, the class, the scheduling, what will you be taught, what will you be given, everything we are going to tell you at 8 o'clock. Okay? Thank you very, very much. God bless you. Thank you from Gradeup. Prep smart, score better, go Gradeup. Thank you.